Good day, Crime Talk aficionados. We have another great show for you. First, that's right, Bryan Kohberger faces some challenges in prison. According to the victim's family, they're apparently not too upset by that. Justices pretend to ponder Adam Montgomery's desperate bid for a new trial. A Florida teen's Oscar-worthy kidnapping hoax deserves a standing ovation. Family of a man shot by the police say, yeah, my son had it coming. You don't hear that every day. Arrest made in a 1984 cold case and an execution carried out in Florida for a 1996 double murder. We've got this day in legal history. Our quote of the day comes from the Supreme Court and their inability to print cash and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications. And I ask you to go hit that bell because sometimes the YouTube algorithm gets messed up, and it's like they wipe everybody from getting notifications of when we go live or put up new content. So please go check that. And yes, you can also check us out on any of your favorite podcasting apps. That's probably the fastest growing area, particularly after CrimeCon, where we've got a big in numbers as it relates to podcasts. There's so many people in the true crime area that don't do YouTube. They just do podcasts. So at least they're listening to us now. So seeing big jump in numbers there. All right. Before we get to the docket, let me remind you to do a couple of things. One, you could go check out the link below. Check out some of that merchandise. Yeah, that's right. That's right. The lawyer shirts are up and available. Go do it. We have this one. Oh, the Constitution matters. Yes, it does. Go check that out, as well as the keychain as well, if you'd like to get some of that cool stuff. Also, let me remind you to go to crimetalksearch.com, sign up for that background subscription service today. When you do, you can do a background search on anyone here in the United States, well, as many people as you desire, and you're going to get a report prepared and emailed to you within minutes, and it's going to have everything you want to know about somebody, ladies and gentlemen. So if you need to check somebody out, go to crimetalksearch.com, sign up today. And remember, whether you want to do one search or 10,000 searches, and you can cancel at any time. Go to crimetalksearch.com. You're going to be happy that you did. All right, let's go ahead and get to the docket for Wednesday, October 15th, ladies and gentlemen. And guess what? Yeah, Bryan Kohberger faces some challenges in prison. I guess that's the case. So Steve Goncalves, father of Kaylee Goncalves, one of the 4 University of Idaho students killed, has shared some insights regarding the reported difficulties faced by Bryan Kohberger in the Idaho maximum security prison. Now, the victims of the 2022 tragedy include Kaylee Goncalves, Madison Mogan, Ethan Chapin, and Zena Kernodle. And in an interview on the Banfield show alongside his daughter, Stephen Goncalves discussed recent developments in the case. And he remarked, hey, there's reports indicating that old Kohberger is struggling within the prison environment, particularly in his assigned block. He appears to be vocal about his rights, asserting that they must be upheld. And Stephen added that individuals who commit such crime must face the consequences, and his complaints within the facility are reportedly not improving his situation. Now, the family also expressed frustration over reports that Lifetime is producing a film about the murders titled Ripped from the Headlines. According to Deadline actor Miles Mary has been cast to portray Kohberger. The daughter voiced her dismay, stating, it's deeply upsetting. My sisters are not merely a headline or material for a Lifetime movie, and the scripted portrayal of their lives is profoundly frustrating. Now, the family was neither consulted nor informed prior to the public announcement of the film. And Stephen Goncalves expressed his shock, saying, it is disheartening that someone feels entitled to tell the story of your child and their closest friend, people you interacted with daily, without your input. It feels as though someone is intruding into your life and exploiting it for display. Couple of things. All right. First, Bryan Kohberger. You know what Bryan Kohberger should do? He should have his mother call prison. Let me give you a quick example. Had a guy, did some bad things, went to prison. Apparently he's not bonding well with other people. Family calls and says, what can you do? He's in danger. You need to get him out of there. And I'm literally like, there's nothing I can do, right? Mom's like, well, should I call down there? No, that will make it absolutely worse. Okay. He's in prison. This is not, he is in grade school and little Johnny is bullying him and you need to let somebody know. This is prison. You're a big boy. The only remedy is to go check yourself into protective custody. All right. Can't have your mommy call the Department of Corrections. Then even the staff will be on you, and wait until the fellow inmates find out about it like that. You will be the biggest target ever. All right. And I do think it's always funny that, the people that break the crime the most, ones that go to the Department of Corrections, are always the ones that demand that their rights are absolutely followed at every juncture. Like Bryan Kohberger saying that he has rights and he expects his meal. Yes, it's always ironic, isn't it? Now, in the whole issue of Stephen Goncalves and the family not being consulted, there's so much public information out there. I hate to say it, but they don't need to consult the family. And if I really was going to get cynical, it sounds like maybe they want to be a part of it and, maybe get a little cash out of the whole thing as well. I don't know. I get their frustration, but it's all public information and knowledge. Certainly it'd be nice to have the family's input, you would think. But if they're not going to be pleased with the project unless they get paid for it, then Lifetime should go ahead with their movie, in my humble opinion. Next on the docket, justices pretend to ponder Adam Montgomery's desperate bid for a new trial. Let's go to Concord, New Hampshire. Oh, look, Adam Montgomery is back, gracing the New Hampshire Supreme Court with yet another plea for a do-over. Today, a panel of justices had the unenviable task of pretending to seriously consider his request for a new murder trial, as if there's any chance if this convicted child killer will waltz out of his 56-year-to-life sentence. Spoiler alert, Adam, don't hold your breath. Last year, a jury found Montgomery guilty on all charges for the brutal murder of his 5-year-old daughter, Harmony Montgomery. Apparently, the whole sentence to over half a century behind bars, the thing didn't sit well with him, so he's back with a shiny new appeal, whining about his supposed trial errors. His laundry list of complaints: the court didn't split his assault and murder charges, let the jury hear about his charming history of abuse, and gasp, show a video of him chatting with police in 2021. Truly the injustice of it all. At the hearing, Montgomery's attorneys put on a brave face, arguing that lumping the assault and murder charges together turned the jury against their obvious misunderstood client. They also claimed that the evidence of Montgomery's prior assault had no place in the murder trial because apparently a pattern of violence isn't relevant when you're accused of killing your own kid. Now, the state, in a rare moment of clarity, pointed out that the murder didn't exactly happen in a bubble. Shocking revelation. A history of beating people up might just provide some context for a murder case. Who knew? Now, if you thought Montgomery's appeal antics were limited to his murder case, think again. He also tried his luck appealing convictions in a separate weapons theft case where he was slapped with 30 to 60 years of being an armed career criminal. His big grievance there: the victim's wife testified about rumors that he swiped the firearms. The horror. Anyway, the New Hampshire Supreme Court is ruling on August 27th, essentially told him to sit down, stating that the testimony didn't sway the verdict. In other words, nice try, but no cigar. The justices are now considering Montgomery's latest appeal, probably with the same enthusiasm one reserves for cleaning out a clogged drain. They didn't bother giving a timeline for their ruling, likely because they're still recovering from the audacity of this guy's thinking he got a snowball chance in hell out of winning. Stay tuned, but don't expect miracles. Now, there's always a chance that he could get a new trial, but having watched most of that trial, I believe he got a fair trial. And remember, this was the trial that he didn't show up to most of the time, ladies and gentlemen. So, hey, if you're not interested in your trial, why should anyone else be, Mr. Montgomery? Next, a Florida teen's Oscar-worthy kidnapping hoax deserves a standing ovation. Bravo, Caden Spite. You 17-year-old mastermind from Florida, truly your flair for the dramatic gives Hollywood a run for its money. Now, the Marion County Sheriff's Office must be thrilled to have spent their Thursday securing an arrest warrant for this prodigy of deception, charged with a laundry list of offenses. Making a false report, presenting false evidence, shooting into a vehicle because, hey, why not? Possession of a firearm by a minor, and of course, fabricating a crime report. A true overachiever, is he not? So here's what took place last month. Spite's parents received a text from their darling son claiming he'd been snatched by 4 shadowy figures in a light-colored van. Cue the Amber Alert, the abandoned truck with doors flung open, and gasp a single gunshot for that extra cinematic touch. The sheriff's office, bless their hearts, launched a full-scale operation, aircraft, ground teams, even horses, because nothing says urgent like a good old-fashioned posse. But plot twist, the evidence didn't quite support Spite's blockbuster narrative. Turns out our budding director had popped into Walmart to grab a bicycle, a tent, and some camping gear essentially for his grand abduction adventure. But Sheriff Billy Woods summed it up nicely. While the young man pedaled off towards Williston, the rest of the country was left wringing their hands, assuming the worst, and his team burned the midnight oil chasing the fairy tale. And on September 26th, police found Spite at 727 West Noble Avenue, casually hanging out with his bike and gun, still insisting that he was the victim of a kidnapping. The audacity. To top it off, he allegedly shot himself in the leg, shattering his femur no less for that authentic touch of, I'm totally not making this up. The truck, just a stage prop with a bullet through the windshield, a splash of blood for effect, and a smashed cell phone for good measure. A witness, probably stifling a laugh, reported seeing Spites pedaling away from the scene. And when investigators peeked at his laptop, they found pure gold. Search queries about collecting blood without pain. Subtle, Caden, real subtle. Apparently, this wasn't his first rodeo, dreaming of a great escape either. In the end, the curtain fell and the warrant was issued. Spite was hauled off to the Department of Juvenile Justice, probably still workshopping his next script. Slow clap for the kid who turned Marion County into his personal stage. Too bad the only award he's getting is a pair of handcuffs. Liar, liar, pants on fire. Okay? Throw the book at him. Throw the book. And maybe get him some counseling as to why he thinks he needs to lie about this to get attention. What, mommy and daddy not giving you enough attention at home? Really? Now here's something you don't see every day. A family of a man that was shot by cops said, yeah, he had it coming. Big plot twist you don't see every day, ladies and gentlemen. The family of Elijah Wilkes, who is the 26-year-old black man gunned down by a Milwaukee police officer, actually thinks the cop was in the right. Yes, you heard that correctly. In a word where those stories usually end up in lawsuits and protests, this family was out there saying, our bad, he messed up. So here's how we got here. On October 9th, Wilkes reportedly decided it was a great idea to pull a gun on an off-duty officer in plain clothes after a fender bender. Now, according to police, video evidence, because of course there's video, shows Wilkes strolling up, smacking the officer in the face with his gun, and then points it at him. The officer, not exactly thrilled about being pistol whipped, fired back in self-defense. Wilkes didn't make it. The family, in a move that's about as common as a unicorn sighting, held a press conference to back the police's story. Their attorney, B. Ivory Lamar, practically gushed over the clarity of the footage, saying it was substantially more reliable because it was filmed in just a few feet away. Apparently, the video lays it all bare. Wilkes made a spectacularly bad call, and it cost him his life. Now, we acknowledge that he made a bad decision yesterday, and unfortunately, it came with the dire consequences, Lamar said, probably while shaking his head in disbelief. Oh, and get this. Wilkes was on his way to his uncle's funeral when he decided to play cowboy. The family tossing out the theory that he was distraught, acting out of character, maybe not thinking straight, sure, because nothing says grieving like pulling a gun on a stranger after a car accident. Well, the Milwaukee police, clearly eager to avoid the unusual social media firestorm, released the video faster than you can say viral hashtag, claiming they wanted to quell misinformation. How noble of them. Wilkes' aunt, Latrice Bell, doubled down, saying they're not even thinking about suing. My nephew, he made a decision he should not have made, and that's just something we have to live with. She said probably while the rest of the double checked the headline to make sure we weren't hallucinating. The family even threw in a balloon to release in honor of Wilkes because nothing screams closure like letting some helium float away while you publicly admit your nephew screwed up. Well, Bell did toss in a half-hearted, I don't think he knew the guy was a cop, but quickly followed up with whether it was or wasn't the encounter. Well, it should have been different. No kidding. Aunt Latrice, maybe don't pistol whip people after a minor car crash. Just a thought. The family now on a mission to spread truth over rumor and transparency over division, which sounds like a bumper sticker for the most bizarre PR campaign of 2025. So there you have it. A family saying, yeah, our guy was wrong, while the rest of us are left wondering if we're still stumbled into an alternate universe. Wilkes was a son, a brother, a grandson, nephew, and apparently a guy who made one heck of a fatal mistake. You can't make this up, ladies and gentlemen, but the family, I love them. Oh yeah, dude was in the wrong. The guy was in the wrong. You don't see that every day. Normally it's, we're going to sue. This was racial. Get the checkbook ready at the city. This particular case, nope. So refreshing. So refreshing to actually hear somebody say, yeah, our guy screwed up. Next on the docket, an arrest made in a 1984 cold case. On October 15th, 2025, Nassau County Police announced the arrest of Richard Bilodeau, a 63-year-old Walmart employee in connection with the 1984 murder and sexual assault of a 16-year-old known as Teresa Fusco. The breakthrough in the 40-year-old cold case was facilitated by advanced DNA analysis conducted by the Federal Bureau of Investigation, marking a significant development in a case that has long haunted the community. Now, Teresa Fusco, an aspiring dancer, was last seen leaving her job at Hot Skates, a skating rink in Lynbrook, New York, on November 10th of 1984. Her body was discovered on December 5th of 1984 in a wooded area near the rink, having been subjected to rape, beaten, and strangulation. The case remained unsolved for decades, with earlier convictions of three men, John Restivo, Dennis Halstead, and John Kogut, in 1986. These individuals were later exonerated in 2003 through DNA evidence after serving an 18-year prison sentence. And guess what? They were ultimately awarded $43 million for the wrongful prosecution. According to the Nassau County Assistant District Attorney, Jaron Rosenblatt, DNA evidence recovered from a vaginal swab matched a sample obtained from Bilodeau. Investigators identified him as a suspect, and in February of 2025, wait for it, retrieved a discarded cup and straw from a tropical smoothie location near the Suffolk County residence. Now, the DNA from this item was confirmed to match the evidence from Fusco's body. At the time of the crime, Bilodeau, then 24, operated a mobile coffee truck in Nassau County and resided with his grandparents approximately 1 mile from the skating rink. When questioned, Bilodeau denied knowing Fusco or recognized her photographs. While the Nassau County District Attorney Ann Donnelly emphasized the reliability of the DNA evidence, stating, "Science and DNA evidence are unequivocal. We are confident in the identification of the appropriate perpetrator." She was addressing the prior wrongful convictions there, obviously. Anyway, Donnelly noted that she was not involved in the original case, but underscored the certainty provided by the current forensic evidence. Now, Teresa's father, Thomas Fusco, expressed relief at the arrest, stating, "I never lost faith in the system. This brings closure to their family, and though the pain of reliving this tragedy persists." He described his daughter as a vibrant young woman whose memory continues to live in his heart. Now, Bilodeau was arraigned on murder charges on October 15th this morning at a Nassau County courthouse and was ordered held without bail with a scheduled court appearance once again on November 21st of 2025. His defense attorney obviously denied the allegation, asserting his client's innocence as well as he should, because his client is presumed innocent until proven guilty in a court of law or, a guilty plea. Well, this arrest also provides a measure of resolution for Fusco's family and the Long Island community, which was deeply affected by this brutal crime and the subsequent legal developments. The case underscores huge impacts of the advancement of forensic technology in resolving long-standing investigations. Well, there was an execution in Florida yesterday. Samuel Lee Smithers, who was 72, was executed by lethal injection at Florida State Prison nearly 3 decades after his conviction for the murders of 2 women in 1996. Yes, ladies and gentlemen, 30 years of appeals. The execution was pronounced at 6:15 p.m., marking Florida's 14th execution in 2025, a state record for a single year. Now, Smithers, previously employed as a church deacon and a landscaper on a 27-acre property in rural Plant City, Florida, was convicted of killing Christy Cohen and Denise Roach in May of 1996. Records indicate that Smithers met both women at a Tampa motel, engaged them for paid sexual encounters on separate occasions, and on May 28, 1996, the property owner discovered Smithers cleaning an axe near a pool of blood in a carport. Police were notified, and the sheriff deputy later observed drag marks leading to a pond on the property where the bodies of Cohen and Roach were both found. Both victims had been brutally beaten, strangled, and submerged in the pond. At the time of the arrest, Smithers was dubbed the Deacon of Death due to his role in the church, juxtaposed with the heinous nature of his crime. During the execution, which commenced at 6 p.m., Smithers was secured to the table with an intravenous line already in place, and when offered the opportunity to make a final statement, he declined, stating, "No, sir." The administration of the legal drug followed, resulting in heavy breathing and minor convulsions before Smithers became motionless. A warden attempted to rouse him without response, and his complexion gradually turned gray. A medic confirmed his death at 6:15 p.m. after checking vital signs. And according to the Department of Corrections spokesperson, Ted Veerman, the procedure was conducted without any complications. Smithers' legal team had recently appealed to the Florida Supreme Court, arguing that his advanced age rendered the death penalty unconstitutional under the 8th Amendment prohibition of cruel and unusual punishment. The court rejected that claim, stating that age doesn't exempt individuals from capital punishment. A final appeal to the United States Supreme Court was also denied without comment on the evening of the execution. This execution coincided with another in Missouri, where Lance Shockley, 48, was put to death for the murder of a state trooper over 2 decades ago. That's right, 20 years later, ladies and gentlemen. With these, United States recorded 37 court-ordered executions in 2025 to date. Florida has 2 additional executions scheduled. Norman Muriel Grimm, 65, convicted of the 1998 rape and murder of a neighbor on October 28th. And Bryan Frederick Jennings, 66, convicted of the 1979 rape and murder of a 6-year-old girl on November 13th. Then we have this day in legal history. October 15th, 1883, ladies and gentlemen, the United States Supreme Court decides that the civil rights cases declaring the Civil Rights Act of 1875 is unconstitutional and limited federal protection against private discrimination, paving the way for Jim Crow laws. Obviously, that was changed many years later, but not soon enough. On this date, October 15th, 1914, President Woodrow Wilson signs the Clayton Antitrust Act, which strengthens the federal antitrust laws by protecting labor unions and prohibiting anti-competitive practices. The Clayton Act outlawed trusts formed by 2 companies with interlinked boards of directors, price fixing with businesses offering competing projects, making agreements with other businesses to control the supply of a product, and abusing power or maintain a monopoly. On this date, in 1970, President Richard Nixon signs the Racketeer, Influence, and Corrupt Organizations, or the RICO Act, providing federal tools to combat organized crime and corruption. Yes, ladies and gentlemen, most of that was for obviously organized crime and labor unions. And today, on October 15th, the United States Supreme Court convened for oral arguments in the case of Louisiana v. Callis, a pivotal case concerning the application of Section 2 of the Voting Rights Act of 1965 to congressional redistricting. The matter addresses whether Louisiana's 2024 congressional map, which established a second majority black district, constitutes unconstitutional racial gerrymandering under the Equal Protection Clause of the 14th Amendment. So, the map was redrawn following a federal district court's determination that the state's prior configuration, featuring only one such district, likely violated Section 2 by diluting black voter power in a state where black residents comprise approximately 33% of the state's population. So, little background. The VRA, enacted to enforce the 15th Amendment prohibition on racial discrimination in voting, empowers federal courts to remedy practices that result in dilution of minority voting strengths, regardless of discriminatory intent. So in 2022, plaintiffs, including black voters and organizations, challenged Louisiana's initial map under Section 2, prompting a lower court to mandate the creation of a second majority minority district. Louisiana's legislature complied, but non-black voters, the petitioners in this case, subsequently filed suit, alleging that race was predominant factor in the new district design, thereby rendering it impermissibly racial gerrymandering. A divided panel on the United States Court of Appeals for the Fifth Circuit affirmed the lower court's approval of the map, leading to this appeal to the United States Supreme Court. The case was initially argued in March of 2025, but re-argued today due to its complexity and the implications of future redistricting. The key issue in the case, the central question, is whether compliance with Section 2 justifies drawing districts where race serves as the primary criterion, potentially conflicting with constitutional mandates against race-based redistricting. Petitioners argue that the map creation prioritizes racial demographics over traditional district principles. For example, compactness and the continuity, invoking precedents such as Shaw v. Reno, which is a 1993 case, which prohibits racial classifications unless narrowly tailored to a competing interest. The respondents, supported by the state and civil rights advocates, contend that Section 2 explicitly permits such remedies to counteract voter dilution, emphasizing that the map aligns with demographics, realities, and historical voting patterns without segregation votes by race. So the proceedings commenced at 10 a.m. Eastern time today with only one attorney, Janae Nelson, representing the respondents, who are the black voters, defending the map due to the case's procedural posture. Petitioners included Larry Joseph and Eric Grime. They had presented earlier in related phases, and the justice engaged in some rigorous questioning, reflecting ideological divides. The conservative justices, specifically Justice Clarence Thomas, initiated a questioning probing the permissibility of a race-conscious remedies under the VRA, and Justice Brett Kavanaugh and Chief Justice Roberts explored temporal limits on Section 2's application, suggesting it might impose undue burdens on states post-Shelby, which curtailed pre-clearance requirements. Justice Amy Coney Barrett questioned the map's reliance on racial data, echoing concerns of packing minority voters. And liberal justices, Elena Kagan, highlighted Congress's 1982 amendment to Section 2, which rejected intent-based requirements in favor of effect-based prohibitions, underscoring the provision's enduring vitality under the 15th Amendment. Justice Sonia Sotomayor emphasized stare decisis in statutory interpretation, cautioning against narrowing Section 2 absent constitutional infirmity. And Justice Ketanji Brown Jackson distinguished Section 2 from invalidated pre-clearance measures, arguing it lacks expiration, aligns with perpetual protections against discrimination. The session lasted approximately 1 hour, with justices appearing divided along, well, familiar lines. No immediate ruling was issued, obviously. The decision is expected sometime in June. What's the big issue about this? Well, the ruling favoring petitioners could significantly curtail Section 2's enforcement, complicating efforts to ensure equitable representations in state with substantial minority populations, and potentially affecting redistricting cycles ahead of the 2026 midterms. Conversely, upholding the map would reaffirm the VRA's role in combating vote dilution, bolstering civil rights protections amid ongoing challenges to electoral maps. And this case underscores tensions between anti-discrimination statutes and equal protection principles, obviously with potential ramifications for voting rights nationwide. We bring that to you, ladies and gentlemen, because it is a huge case at the United States Supreme Court. And yes, it's a crime show, but guess what? Crime, it's all about the constitutional law. Supreme Court's in session. Everybody should be interested in this stuff. It's what affects your everyday life. It really does. Next on the docket, a quote from the United States Supreme Court when they were discussing the shutdown and as it's relating to the court, because eventually the court's going to have to shut down because they don't have any more money. They're using money now that was collected by fees. So the U.S. District Courts, the Court of Appeals, and the United States Supreme Court. And the quote of the day by Lynn Dennison states, quote, "Although the court does have awesome powers, it has no authority to print its own money." There you go, ladies and gentlemen. The courts ought to be shutting down any day now, at least in the federal court system. They're keeping it open. And I can tell you also the CJA panel attorneys, where private attorneys are appointed, they ran out of money months ago. And even when they do have money, it's only going to be a small percentage of what they owe. So basically, private attorneys that represent people in federal court where they qualify for counsel, they haven't got paid in months, and there's no way that they're probably going to get paid anytime soon either. But the attorneys go and do it because they know it's the right thing to do. Next on the docket, our dumb criminal of the day. Now, an ex-strip club worker nailed for hurling a cheeseburger. What an epic drive-by tantrum. So look, another shining moment for humanity. A disgruntled former employee decided to make a grand statement at a Tampa area strip club. And no, it wasn't with a strongly worded email. On Friday night, 26-year-old Jordan Cotto, C-O-T-T-O, rolled up to Atlantis Gentlemen's Club, supposedly to chat with management. Well, guess what? Things didn't go as planned. Instead of using his words like a grown-up, Cotto allegedly escalated from verbal sparring to launching a cheeseburger from his car like some fast food vigilante. The burger, in all its greasy glory, smacked a male victim square on the shoulder, inflicting what can only assume was a devastating blow to his pride. Miraculously, the victim survived this culinary assault without serious injury. When the cops showed up, Cotto didn't even try to play innocent. Oh no, he proudly admitted to flinging the burger and, get this, declared he'd do it again. No regrets, no remorse, just pure, unfiltered burger-throwing swagger. The police, probably struggling to keep a straight face, noted that no actual weapons were involved in this high-stake patty attack. Cotto, looking like he's auditioning for a role as Angry Burger Guy, was slapped with a misdemeanor battery charge and tossed into county jail. A judge, likely wondering how their career led them to this moment, let him out on his own recognizance, but sternly ordered him to steer clear of the victim. Oddly, the court didn't see it fit to ban him from wielding cheeseburgers in the future, guessing there's not ready to infringe on his right to bear fast food. And because Cotto's life isn't apparently a highlight reel of great decisions, this isn't his first brush with the law. Just last month, he was nabbed for breaking into his uncle's boat and swiping a gun, which he pawned for a relative cool $300. Prosecutors, in their infinite wisdom, though, decided that wasn't worth pursuing. Clearly, they're saving their energy for the cheeseburger caper. All right, ladies and gentlemen, that's all we have for today. Hope you enjoyed the show. Thanks for watching, and remember, the Constitution matters.